Hello, and thank you for having me today. Today, I'm here to discuss a topic that affects every parent, student, administrator, and staff member: students' constitutional rights in school. I'd like to start off by giving a bit of history. The U.S. Constitution doesn't just stop at the school doors. Many students take the constitutional rights inside of their classrooms, most notably under the First, Fourth, and 14th Amendment. The landmark case, Tinker versus DeMond Independent Community School District, was a case where students wore black armbands to protest the Vietnam War and were all suspended. The Supreme Court sided with the students, affirming their right to a peaceful expression as long as it didn't disrupt the school environment. The Fourth Amendment, which protects unreasonable seizures and searches, was addressed in New Jersey versus TLO in 1985. The court ruled while students have privacy rights, school officials can conduct searches based on reasonable suspicion rather than probable cause. Finally, the 14th Amendment Due Process Clause ensures the students are treated fairly in disciplinary actions, a concept explored in Goss versus Lopez, 1975. The impact of school type. Well, the legal applications vary differently from school to school. Public schools are government entities, so constitutional rights apply most directly. And then there's charter schools. Though publicly funded, depends on the state law and their degree of autonomy. Private schools, especially those not receiving public funds, are largely exempt from constitutional constraints. Instead, student rights are guided by contract laws and the school's own policies. And then we have our virtual schools where things get a little bit complicated because student speech, conduct, and attendance may occur entirely off physical campuses. A current issue that is pretty popular right now is student speech and social media. So I'd like to take a moment to discuss this hot button issue. Consider the case of Mahoney Area School District versus BL 2021, where a high school cheerleader posted a profanity-laced rant on Snapchat after not making the varsity team. She was suspended from the team. The Supreme Court ruled 8-1 in her favor, stating that her off-campus speech, while cruel, was protected under the First Amendment. Now, the supporters of the ruling argue that schools district control what students say in their free time, especially off campus. They agree with that. Then there's the critics, on the other hand, that argue that schools should be able to discipline off-campus speech that affect the learning environment, like cyberbullying or threats. They worry this ruling may weaken school authority and affect them being not able to maintain safety and order. Other cases, such as Kowalski versus Berkeley County Schools in 2011, have upheld school actions when off-campus online speech amounted to targeting, bullying, showing that context matters greatly. My personal perspective as an educational leadership or a leader. As a leader of future schools, I believe that student voice matters and protecting it is vital for civic development. However, this protection must be balanced while maintaining a safe, learning, and respectful environment for all students. The Mahoney decision rightly reaffirmed students' off-campus rights, but it also acknowledged that some online speech, such as threats or harassment, can be regulated. We must educate our students on digital citizenship so that they understand their responsibilities along with their rights. In closing, the conversation about students' constitutional rights is a conversation that's far from going away, and it shouldn't. By staying informed and leading with legal clarity and ethical care, schools can create environments that foster learning, respect, and freedom. Again, I want to say thank you for having me as a speaker today.